First of all, let's be clear that this video is not about crying about any decision. This video is about educating and pointing out the facts. You see, there's some things that take place in these civil proceedings against self represented litigants that they don't want the rest of the outside world to see. The inside self dealing business swindles of the corruption. And flat on its face, no one can really comprehend it. And I'm not saying that I entirely comprehend it myself because I'm not a trained professional. But I can tell you I'm intelligent enough to follow the leads and do the factual research in the background. So during the proceeding, a motion for reconsideration and unlimited civil case action for a personal injury. This personal injury involves a government vehicle and a government entity who failed to provide for the statutes and abide by them. And because he didn't abide by them, he caused harm to me and personal injury and damage to my property. And not only did he not follow that statute that was designed to protect, he violated additional statutes that were designed to protect for the very same purpose, such as identifying yourself during a vehicle accident or having a statutory requirement for utilizing your lights and sirens during a motor vehicle code 3 response, and the necessary requirements to take evasive actions to avoid collisions with pedestrians and others on the roadway who have a right within themselves to be there. And the statutory provision is you must adhere to the statute in order to be protected from immunity or by immunity. So, the overall point of this is it comes down to abuse of discretion, and they love the site Repelea v. Campbell, 1994, Supreme Court ruling. However, they don't disclose all of the important greedy stuff that's all about them in the very same citation, Rapalea v. Campbell, 1994. It comes down to the exception of abuse of discretion, where they exercise their apparent authority and flash their I'm an attorney licensed to practice law in all the state courts of California and all the federal courts and blah, blah, blah. And then here comes the first lie. I have firsthand knowledge by the records of my department that keeps in the course of the ordinary business. However they say it, something along those lines. But the fact is, this statement is a fraudulent statement because it's in fact second and third hand knowledge that's hearsay provisions that you're just a borrowed employee from another branch of the same agency appearing to interfere with contractual agreement to prevent the injured person from going before the judge and providing evidence and proving up to the judge that the injury actually in fact happened. But instead, since there's so much at stake for you, you have to lie your whole way through it. And because you know, as this general order says, you know there's no record of it because there's a court absence of court reporters available. So as it says, just 6 years ago, our Supreme Court warned that the absence of a court reporter at trial court proceedings and the resulting lack of a verbatim record of such proceedings will frequently be fatal to the litigant's ability to appeal. Holy shit. So I asked, citing this General Order 11 that just issued, if it can be recorded since there's no shorthand reporter present. The audacity of this so-called honorable judge that's not even elected but appointed to the seat to fulfill the empty vacant bench of their little plague of corruption sitting over there in Pomona Courthouse, and allow the trenches of the dirty, pragmatic protagonist nonsense that they call legal reasoning or the ratio decidendi bullshit that they use to abuse you with their subterfuges and stratagems And it's just significantly to chill a litigant's enjoyment of the fundamental protections of the right to appeal, and they know it. See, California is not even constitutionally required to establish avenues of appellate review, but it is now fundamental that, once established, these avenues must be kept free of unreasoned distinctions that can only impede open and equal access to the courts, like a represented individual without having any representation. It's just a mirage of lies that is just built up in a burdensome conflict of interest with a limited liability partnership in connection with property. See, these avenues must be kept free of unreasoned distinctions, and this general order too reflects the need for procedures that promote equal access to fundamental protections of the right to appeal. The Los Angeles Superior Court can no longer reliably staff its courtroom with court employed certified shorthand reporters. Wait a minute. This is an omission of a fact. This is negligence on the part of Los Angeles Superior Court. They have an obligation and a duty to provide reliable staff for its courtroom, and they admit right here that they are incapable of doing so. And the vast number of litigants are left without a verbatim transcript. And the reason it's a vast number is because the state abuses them by the vast number of victims. Believe it or not, you just haven't fell victim to one of them yet, have you? Well, anyway, any verbatim transcript of the record of what occurred during a hearing may have profound impact on their rights and their lives. So, this court held more than 332,000 hearings for which there was no verbatim transcript of proceedings with the parties at the appellate rights accordingly, and they were limited. Wow. This is a ugly, 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 ugly controversy. This here is the secretary's dirty affair that she hopes you never discover. So, I hope I just shared a little bit of things with you here, and uh, I'm not providing you legal advice or telling you I'm giving you legal information or legal education. I'm providing you public available information that is available for you to access publicly for free. You only have to research for it, read it, apply yourself to it, try to understand it, test yourself, grid yourself, find test books out there. There's free flashcards. There's all kinds of legal material that you can get your hands on through the internet. And if you applied yourself, you could find the ratio decidendi with this legal reasoning and figure out and see exactly what it is that they're doing to us all and getting away with. It ain't over yet, motherfuckers. Got me fucked. You can't, you can't. I dare you to call me a vexatious litigant. You can't, because I have a valid standing argument.